Living with a homeowners association can be a dream, or it can be a total nightmare. Today, we're going to get into the weeds of what happens when that nightmare spills over into a full-blown courtroom drama.
It's a question you might have even screamed into a pillow at some point. So we're going to find out the answer. We are going to tear apart a real-life case where one homeowner decided he'd had enough and took his HOA to court on 4 different complaints.
All right, let's get into the specifics of this case. White versus Aspen Shadows. Our story kicks off with a guy named Robert A. White. He buys a condo back in 2014 in Flagstaff, Arizona, and well, it wasn't long before he and his HOA were seriously butting heads. So the whole lawsuit boils down to 4 big issues. You've got a damaging water leak, some kind of broken pump, a neighbor making a racket, and a fight over paperwork. We're going to break them down one by one and see what each side said, and most importantly, what the judge had to say about it all. Okay, first on the list, the water leak. This is a classic, right? A leak from the unit upstairs causes a ton of damage in Mr. White's condo, and that sets off the age-old question: who's going to pay for this mess? Now pay close attention to the wording here because this is everything. The homeowner says the HOA withdrew his claim, but the HOA comes back and says, we submitted the claim, but the insurance company itself investigated and denied it. And why? Because their investigation found the damage was from a slow, long-term drip. The kind of thing that's a really common exclusion in insurance policies. And yep, the judge sided with the HOA. Look, the crucial thing here is that the HOA's job was to have insurance, which they did. Their job wasn't to guarantee every single claim gets approved. The insurance company made its own call based on its own policy rules, so the homeowner just couldn't prove the HOA did anything wrong. Okay, complaint number 2, the pump and the wall. This whole thing is about a piece of machinery called a grinder pump, which was basically essential for handling sewage, but only for the homeowner's unit. And again, you've got 2 totally different stories. The homeowner saying a bad wall let storm debris break his pump, and he's out $2,500. But the HOA says they sent an engineer out who found something way simpler. The lid was just half off. He said he just cleaned it out, put the lid back on tight, and confirmed the pump was working just fine. Okay, pause. Before we get to the judge's ruling, we need to wrap our heads around a super important legal term from the HOA rulebook: limited common element. Basically, since this pump only served Mr. White's condo, it gets this special label. And trust me, this little phrase changes the whole game. So, the judge looked at this and basically said 2 things. First, the homeowner never actually proved the pump was broken in the first place. But second, and this is key, even if it was broken because it was a limited common element, the rules allowed the HOA to charge the owner for the repairs anyway. So, their refusal to pay was a moot point. That's another loss for the homeowner. All right, on to our 3rd complaint, and oh man, this is a classic HOA drama: the noisy neighbor. The homeowner claimed the guy upstairs had a hardwood floor that violated the rules and was just making way too much noise. The homeowner's argument is pretty simple. Hey, enforce the rules. But the HOA fires back with a 1-2 punch. First, they say the other owner might have gotten a variance years ago. But their real knockout blow was pointing to a specific clause in the rule book that basically says, hey, you live in a condo, you're going to hear your neighbors, and you can't sue us over it. And here it is. This is the exact fine print that can make or break a case like this. It spells out that owners just have to accept a certain amount of noise. When you buy a place with an HOA and you sign those papers, you are legally agreeing to sentences just like this one, whether you read them or not. So, no surprise here. The judge's decision was pretty cut and dry. The floor had been there for years before the homeowner even moved in. But the nail in the coffin was that noise waiver in the rules. He had legally agreed to it when he bought the place. Case closed. And that brings us to the final complaint: the fight over docs. This one's a little different. It's not about a leak or noise. It's about paperwork and procedure, going all the way back to when he first bought the condo. The homeowner's argument was basically, hey, the law says you have to give me the rules before I buy, and I wanted paper copies. But the HOA said, whoa, not so fast. State law specifically says we can provide those documents electronically. They even said when he refused the digital copies, they went ahead and mailed him paper ones anyway. And for the 4th time, the judge pulls out the rule book, in this case, the actual state law, and fines for the HOA. The law was crystal clear. Delivery can be in either paper or electronic format. Just because the homeowner wanted paper didn't make the HOA's perfectly legal offer of an electronic copy a violation of the law. So, let's recap: 4 complaints filed and 4 complaints shut down by the judge. Now we get to the final verdict and the single most important legal idea that decided this entire case: the burden of proof.
The final order was short, sweet, and absolutely brutal. Petition dismissed. The homeowner lost, big time, on every single issue. This is the big question, right? Why? It's not just that he was wrong. It's because he, as the one making the accusations, failed to clear a very specific legal hurdle.
And that hurdle is called the preponderance of the evidence. Now, it sounds all fancy and legal, but all it really means is that the person filing the lawsuit has to prove their story is more likely true than not. You don't have to prove it beyond a shadow of a doubt, but you do have to tip the scales in your favor, even if it's just by a little bit.
And on every single point, the homeowner just couldn't clear that bar. With the leak, he proved a claim was denied, but he couldn't prove the HOA's insurance was wrong. With the pump, he never proved it was actually broken. With the floor, he couldn't get around that waiver he had already agreed to. And with the documents, he was literally arguing against what the state law allowed. The scales never tipped.
And this, right here, is the ultimate takeaway. In a fight like this, the entire responsibility, the entire burden, was on the homeowner to come with receipts and prove the HOA broke the rules. It wasn't the HOA's job to prove they were innocent. All they had to do was show that his proof just wasn't good enough.
So it leaves us with a really important question. The homeowner might have felt deep in his bones that he was 100% right, but what this case shows us is that in the eyes of the law, feeling right and being able to prove you're right are 2 completely different things.